All right, so in this chapter, we are moving away from statutory law into another major source of legal authority, which is case law. So if statutes tell us what lawmakers intended the law to be, then the judicial opinions show us how that law actually operates in the real world. So the courts interpret statutes, they apply legal principles, to specific facts. They resolve disputes between parties, and in many situations, they create precedent that guides future decisions. All right. Students often entering into legal studies, they think that legal research is primarily about finding statutes, and very quickly, they discover that lawyers spend an enormous amount of time reading cases. And the reason is simple. Statutes often only answer one part of the question, all right? And courts spend years interpreting statutory language, defining ambiguous terms, identifying, exceptions, and then resolving disputes about how the laws should be applied. So imagine that a statute prohibits discrimination at work. At first glance, the language may seem pretty straightforward, but what exactly qualifies as discrimination? What evidence must a plaintiff present? What defenses are available to an employer? What remedies exist if discrimination is proven? Those are the questions that are often answered through the judicial opinions rather than through the statutory language itself. So case law, therefore, it serves as the practical application of legal principles. So it allows researchers to see how judges analyzed the disputes, how they interpreted, legal authority, and then how precedent is actually developed over time. Now, one other thing that you should understand is that not every case carries the same weight. Some decisions become highly influential because they establish new legal principles or they clarify an important area of law. Others resolve narrow disputes without creating significant precedent. So learning how to identify the difference becomes one of the most important legal research skills that you're going to develop. And this chapter marks a major transition in the way that a lot of students think about the law, because instead of focusing primarily on legislation, we are going to examine how the judges reason through legal problems and how those judicial decisions actually shape the legal system itself. Now, one of the first things that a lot are surprised to learn is that not every judicial opinion is officially published. And at first, that might seem strange because if courts decide cases every single day, well, why wouldn't every decision automatically become some sort of published precedent? And the answer lies in practicality. Courts issue an enormous amount of decisions every single year, and many of those decisions simply apply to existing law, or they apply the existing law to just a routine set of facts, and they don't create anything new. So if every opinion we treated as major precedent, legal research would become overwhelming very quickly. All right, so for that reason, the appellate courts often decide which opinions deserve official publication or not. All right, and generally speaking, courts are more likely to publish opinions that contribute something meaningful, to the development of the area of law. Now, a case may deserve publication because it establishes a new legal rule. Another may be published because it clarifies an area where courts previously disagreed. Sometimes a decision addresses an issue of continuing public importance, or it provides, particularly some sort of valuable legal analysis that future courts and attorneys may find useful. Okay? You should understand that publication is not simply about making a case available to the public. This reflects the court's judgment that the opinion has broader significance beyond the immediate dispute between the parties. And that distinction becomes especially important when researchers encounter unpublished opinions. Now, in many jurisdictions, unpublished cases have very limited precedential value, okay? And they may not be cited under, ordinary circumstances. The rules vary, though, based on the jurisdiction, and the underlying idea remains the same, though. Courts generally want attorneys relying on decisions that contribute meaningfully to the body of precedent rather than treating every routine opinion as authoritative law. All right. And this introduces students to one of the recurring themes in legal research, and that is that finding a case is not enough. Researchers also understand, or they must understand rather, the status of the case. The precedential value and whether or not jurisdiction permits reliance upon it. So strong legal researchers, therefore have to pay attention not only to what a case says, but also to whether the case carries the authority that is necessary to support a legal argument. Now, when students first open a judicial opinion, the document can feel very intimidating. You have names and citations and procedural references and attorneys and judges and legal terminology, and then you have pages of analysis that might seem very difficult to follow, right? Now, one important skill that new legal researchers develop is learning how to break an opinion into its recognizable parts. All right, so every published case has certain pieces of information that will help the researchers to understand the case that they're reading. The case name is usually the first thing that students notices. It's going to identify the parties that are involved in the dispute, and it will often provide clues about the nature of the case. So over time, you'll become surprisingly good at recognizing whether a case involves a criminal prosecution, a civil lawsuit, a government agency, or some sort of, constitutional challenge simply from the names that are appearing in the caption. You also need to know what court has decided the case and when that decision was issued. And those details matter because authority is heavily influenced by jurisdiction and hierarchy. So a decision from the United States Supreme Court is going to carry very different precedential weight than a decision from a trial court. All right. Now, likewise, the date of the decision may also become important if the law changed after. All right. So as you continue reading, you'll often encounter some editorial materials that are placed before the opinion itself. These are going to be like your summaries, and they can provide a very helpful introduction, to the dispute. All right, but you should remember one thing, and that is that they are not a part of the court's actual opinion. These are simply going to be tools that have been created to help you navigate as a reader, going through the case more efficiently. All right. And eventually the researcher is going to reach the heart of the document, which is the opinion itself. And this is where the judges explain the facts. They identify the legal issues, they analyze the law, and they reach a conclusion. All right. The opinion is the portion that future courts, attorneys, and researchers examine most carefully because it reveals the court's reasoning process. All right. And honestly, the reasoning is often more important than the outcome alone. So students sometimes focus immediately on who won and who lost, but lawyers are usually more interested in why the court reached that result. Okay. So the reasoning is what is going to allow future courts to either apply or distinguish or to extend the decision in later cases. And then by the end of the case, the court announces its decision. And the decision just tells the reader what happened, procedurally. The judgment can be affirmed, reversed, remanded, modified, or otherwise, resolved. And understanding that outcome is going to allow researchers to see how the dispute ultimately concluded and how the court's reasoning affected the parties involved. Okay? So one of the biggest transitions that you're going to make is moving from reading cases like stories to reading cases like researchers. And once you recognize all of the different parts, the judicial opinions or decisions themselves become far less intimidating and far more useful as research tools. Now, some may assume that there is only one place where a judicial opinion is published. And in reality, many cases appear in multiple publications. And so understanding the difference between official and unofficial sources becomes an important part of legal research. So an official publication is one that has been authorized by law or by a governmental authority as the formal publication of legal materials. Historically, official reporters were viewed as the definitive source for judicial opinions because they represented the version that was approved by the government itself. Now, unofficial publications developed for a practical reason. So, legal researchers needed easier and more efficient ways to access cases. Commercial publishers, they recognized that demand and they began, producing reporter systems that often included research tools and indexing systems and editorial enhancements and organizational features that were designed to help attorneys locate authority more efficiently. So unofficial publications often became the more popular source among practicing attorneys than the official publications. And the reason was not because the cases differed. The opinions themselves, they remained the same, but what differed was the usability of the publication. So a commercial publisher might organize opinions more effectively. They might provide better indexing. They might include like research references or, offer some sort of additional tools that help the researchers locate whatever related authority. Those enhancements made research faster and more practical, all right? And that reflects something that we see repeatedly throughout legal research. The challenge is rarely obtaining information. The challenge is in organizing information, and I mean in such a way that allows researchers to use it effectively. Okay. Now, today, electronic databases have changed a lot of that conversation surrounding official versus unofficial publications, right? And researchers, they now often retrieve the opinions digitally without thinking much about the publication source. But the distinction still matters because legal citations, precedential authority, and publication practices, they continue to influence how cases are identified and referenced. So understanding official versus unofficial publications will allow you to appreciate how legal information is both collected and organized and even distributed throughout the legal system, okay? And it helps to explain why a single judicial opinion might appear in multiple places while still representing the same underlying decision. Now, as the number of judicial opinions increased in the United States, legal researchers faced a huge problem, all right? Courts were issuing decisions in every state, and locating those decisions efficiently became increasingly difficult. So researchers needed a system that would organize opinions in a way that made them accessible regardless of where they were decided. So West Publishing responded to that need by creating what is known as the National Reporter System. So rather than organizing cases state by state, through like entirely separate publications, West grouped states into regional reporter systems. So that allowed researchers to locate appellate decisions through a more standardized structure and created a level of consistency that significantly improved legal research. Okay. Students sometimes become confused when they first encounter reporter abbreviations because the citations seem kind of unfamiliar, and they're definitely disconnected from a state where the case originated. So like a researcher might see a citation that has N.W.2D or P.3D, right? And they have no idea what jurisdiction is necessarily involved. But over time, researchers learn that those abbreviations identify those regional reporters rather than the individual states. Okay, so the National Reporter System became one of the most influential developments in legal publishing because it provided this unified framework for organizing and accessing judicial opinions. So instead of navigating dozens of completely separate publication systems, researchers could work within a more consistent structure that grouped states together geographically. And honestly, again, this was a major advancement for legal research. So imagine trying to conduct multi-state research without any standardized reporting system. Every jurisdiction would have its own publication methods, their own, organizational structure, and their own indexing approach. So you would have researchers spending an enormous amount of time simply locating opinions before they could even analyze them. One other thing that you should understand is that the National Reporter System did more than publish cases. It introduced research tools and organizational methods that helped researchers identify relevant authority much more efficiently. And that eventually became a foundational component of modern legal research. Okay, so even today, even when most research occurs electronically, those reporter citations remain important because they provide a standardized way of identifying judicial opinions. Legal professionals, they continue using reporter citations in brief and memoranda, court opinions, even scholarly writing, because the system remains very deeply embedded into legal practice. So, understanding the National Reporter System will help you to appreciate how that legal information became organized on a national scale and why reporter citations continue appearing throughout modern legal research. Now, as you continue learning about the reporter systems, you'll begin realizing that, it covers virtually the entire country through this series of regional publications. And the purpose is not simply geographic convenience. It was to create this predictable and organized method for publishing these appellate decisions from multiple jurisdictions while still maintaining consistency across the reporting process. All right, so you'll learn to recognize the reporter citations as the indicators of where the opinions were published rather than treating them as a random collection, of just letters and numbers. And once you understand, or once your understanding develops of that, citations are going to become a lot easier for you to interpret. Now, one of the things that I would say is a mistake that beginning researchers make is focusing heavily on trying to memorize the reporter abbreviations instead of just understanding what system it is and what it's trying to accomplish. All right. The real value, again, is organizational. It gives us this framework that is going to allow the researchers to locate and cite these judicial opinions consistently, regardless of where the case originated from. All right. And these reporter systems became especially valuable long before electronic databases existed. Attorneys needed a reliable way for finding the opinions, for comparing the authority, and for identifying precedent across multiple different jurisdictions. And that's where the National Reporter System came in because it created that consistency. And even though, today you're going to retrieve cases through Google Scholar, Westlaw, Lexis, whatever, court websites even, the reporter citations are still going to be deeply connected to the legal profession citation system. Courts are still going to reference them. Your legal writing is still going to rely on them, and researchers are still going to encounter them constantly throughout legal authority. And this is the last one. I'm just hoping that you would pause to read them. But anyhow, understanding why the system was developed it'll give you an appreciation for the legal research generally. Every major research tool exists because earlier researchers encountered, practical problems that required solutions. And the reporter system solved the problem of organizing this massive amount of case law into a structure that researchers could actually use. So now let's talk about Supreme Court cases. When students first begin researching Supreme Court opinions, they're often surprised to discover that the same decision may appear in multiple publications. And at first glance, that seems unnecessary. If there's only one Supreme Court opinion, then why would it need to be published in more than one place? And the answer lies in the history of legal publishing and the development of the different reporting systems. So the official publication for the Supreme Court decisions is the U.S. Or the United States reports. That reporter is authorized by the federal government, and it serves as the official source for the Supreme Court opinions. Now, when you read citations that have U.S., they are looking at a citation from the United States reports. All right. Now, over time, commercial publishers also began publishing Supreme Court opinions. Those unofficial publications provided additional research tools. It gave you the indexing system that was very much needed and found useful by many. And then you have the editorial enhancements there as well. Now, as a result, the Supreme Court cases often appear in multiple reporter systems, even though that underlying opinion remains exactly the same. Okay. And I know you might worry that different publications might contain different versions of the case, but they do not. The judicial opinion itself remains unchanged no matter where. What is going to vary is the publication source, the citation format, and any accompanying editorial materials that are provided by the publisher. Okay, and honestly, this is another example of something that we've seen repeatedly throughout legal research. The legal profession places a lot of value on organization and accessibility. So multiple publication systems developed because researchers needed practical ways to locate, to analyze, and to cite the authority efficiently. All right. Another thing for you to understand is that the Supreme Court opinions, they take up a unique position within the American legal system. So because the Supreme Court sits at the top of the federal judiciary, its decisions often establish binding precedent for courts throughout the country. So that means that researchers pay particularly close attention to any new Supreme Court opinions because those decisions can reshape entire areas of law. So a single Supreme Court case can affect, constitutional doctrine. It can alter statutory interpretation. It can redefine procedural requirements, and it can even change how lower courts handle legal disputes for years to come. And that's one of the reasons that Supreme Court opinions receive such extensive publication and distribution, I should say, because their influence extends far beyond the parties involved in the individual dispute. Researchers, attorneys, judges, scholars, students, all of them are going to rely on access to those decisions because of their significance when it comes to precedent. Now, one of the most dramatic changes in modern legal research involves the speed with which Supreme Court opinions become available to the public. So students today often assume that immediate access to judicial opinions has always existed. Honestly, because it feels normal to receive information instantly. But historically, legal professionals sometimes waited very significant periods of time before newly issued opinions became widely available throughout the traditional publication systems. And technology changed that reality completely. So today, researchers can often read Supreme Court decisions within minutes of its release. Courts publish opinions electronically now, and legal research services quickly distribute the full text through the online databases. So that means that attorneys and journalists, professors, students, and even members of the public can begin analyzing major decisions almost immediately. Okay? And this speed has changed the way the legal profession works in many important ways. So like when the Supreme Court issues a major constitutional decision, again, legal analysis can begin almost immediately. Law firms will circulate an alert. News organizations are going to publish, coverage on it. Scholars are going to begin with commentary, and attorneys are going to start evaluating how the ruling might affect their clients. All right, so the conversation surrounding a major decision now develops in a real time rather than over days or weeks, okay? Now, at the same time, you should understand that the rapid access does create its own challenges. So like when a major opinion is released, people will often, rush to summarize it before they fully understand it. Headlines, are going to oversimplify the holding more often than not. Commentators are going to focus on only one aspect of the decision, and public discussions sometimes begin before anyone has even carefully read the entire opinion. That happens on social media all the time. Strong legal researchers, though, are going to develop a habit of returning to the actual case itself. Rather than relying entirely on news coverage or secondary commentary, they're going to read the opinion. They're going to examine the court's reasoning, and they're going to determine what the court actually held. This becomes especially important with Supreme Court decisions because public discussions often focus on political implications while overlooking the legal analysis that is driving the decision. Okay, and honestly, it's another example of a more broad lesson in legal research. Access to information is valuable, but understanding the information remains that real skill. So technology can deliver the opinions within minutes, but it's that careful analysis that is still going to require, patience and attention and critical thinking, and those take more time. Now, as you begin working with cases from different reporter systems, you will eventually encounter a problem, a practical problem, okay? The same judicial opinion may appear in more than one publication, and each publication may use different page numbers. And at first, that may not seem like a major issue at all right? After all, the opinion's the same, right? So why should the page numbers matter? This answer becomes obvious once you start citing authority. So legal professionals have to be able to direct readers to the exact location of a quotation, holding, or discussion within a case. So if two researchers are using different reporter systems, they need a reliable method for identifying the same passage even when the page numbering differs. All right, this is where star paging becomes important. So star paging allows researchers to identify where the page breaks from one reporter system and correspond to the page breaks in another reporter system. In essence, it's creating a bridge, right, between different publications with the same opinion. All right. This is one of those concepts that sounds incredibly almost weird, but it's technical, right? Until you see why it matters in practice. So imagine that, two attorneys are discussing a Supreme Court opinion, and one attorney is working from an official reporter while the other one is using a commercial database. Without some method of connecting the page numbering system, and locating the same discussion inside the opinion, it could become very frustrating very quickly. So star paging is going to solve that problem by allowing researchers to move between the citation systems while still referring to the same portions of the opinion accurately. All right. Another thing that you should understand is that star paging becomes extremely important during the transition from print research to electronic research. Courts, attorneys, scholars, they still relied heavily on traditional citations, but you have increasing numbers of researchers who were accessing these opinions digitally. So the legal profession needed a way to maintain citation consistency, like across the different formats. So star paging was part of that. And it reflects something larger about, I guess, legal research more generally speaking. And again, the profession places an enormous emphasis on precision, right? Researchers are not simply expected to identify authority. They are expected to identify authority accurately enough that someone else can immediately locate the exact material that's being referenced. And that level of precision may seem excessive at first, but it becomes essential when legal arguments depend on particular language or specific holdings or even more narrow portions of judicial reasoning. So the National Reporter System became so successful not because it collected judicial opinions, but because it helped researchers to navigate those opinions more efficiently. Some will assume that legal publishing is merely about reproducing court decisions. In reality, legal publishers have spent decades developing these tools designed to help researchers find relevant authority without reading thousands of cases individually. All right. And one of the biggest challenges in legal research has been about organization. I can't harp on this enough. Again, courts issue enormous amounts of opinions every single year. And so the researchers needed methods for locating this relevant authority very quickly while avoiding countless irrelevant decisions. And West addressed this challenge by building this variety of research aids directly into the reporting system. And those features helped researchers to identify important cases, to trace the legal concepts, to locate related authority, and to navigate large collections of opinions more efficiently. Okay. And a lot of those innovations, they influenced modern legal research far beyond printed books. So the most significant example is probably the key numbering system. And this you will encounter this repeatedly throughout legal research, but it organizes legal issues into categories and subcategories, and it creates a structured method for locating cases addressing similar legal questions. Okay, so what made this innovation so powerful was it focused on legal concepts rather than specific words. All right, so researchers did not have to guess the exact terminology that was used by the court. Instead, they could locate authority based on underlying legal issues being discussed. That dramatically improved research efficiency because courts often describe similar concepts using different language. All right, so a keyword search alone might miss important authority, while concept-based organizational systems help researchers to identify cases addressing the same issue even when the wording differs. All right, and that reflects, again, one of those recurring themes of legal research. The most valuable research tools are often the ones that help the researchers to think more clearly about the legal problems rather than simply giving them more information. And the National Reporter System essentially became much more than a publication system. It evolved into a research framework that helped generations of attorneys and judges and scholars and students to locate and analyze legal authority more effectively. One of the things that often surprises beginning legal researchers is the whole concept that the single case can have more than one citation. Some are accustomed to thinking of citations as unique identifiers. So if a case has a citation, they naturally assume there's only one. But in legal research, the same judicial opinion appears in the multiple reporter systems, which means that the same case may be cited in different ways depending on the publication that's being used. All right, so that's where the concept of parallel citations becomes important. A parallel citation simply reflects the fact that the case was published in more than one reporter. All right, so the underlying judicial opinion remains exactly the same. What changes is the publication source and the citation format that's attached to it. All right, and honestly, that can feel very confusing at first because students sometimes think that they're looking at different cases when they encounter the multiple citations. But in reality, they're often looking at the same opinions that are just being reproduced in different reporting systems. So the ability to locate the parallel citations becomes particularly important during the years when researchers relied heavily on printed materials. So attorneys, judges, scholars, they might have all been working from different reporter systems. So researchers needed reliable methods for moving between those publications and identifying the equivalent citations. So even today, when electronic databases do make locating opinions much easier, the parallel citations still appear regularly in the judicial opinions, in the briefs, any kind of research materials, legal scholarship, all of that stuff, right? So you need to recognize that the multiple citations may point to the same authority. Another thing that you should understand is that finding parallel citations is not simply an exercise in citation formatting. It is really about ensuring researchers can locate authority regardless of what publication system they happen to be using. All right, and honestly, this reflects one of the more broad goals of legal research, generally speaking. The legal profession places a lot of emphasis on making authority both identifiable and traceable and verifiable. So when a researcher begins with one citation or another, the goal is always to arrive at the same underlying judicial opinion and to analyze its legal significance accurately. Now, one of the biggest mistakes that a a lot of beginning law students and legal studies students make is trying to read cases the same way that they read ordinary books. A judicial opinion is not written primarily to entertain, persuade the public, or to tell a story. In most cases, it is not going to entertain, but it is written to explain how the court resolved a legal dispute. So because of that, cases require a different reading strategy than most materials students have encountered previously. Okay? So when students first open a case, they often become overwhelmed by all of the details. There's usually unfamiliar, terminology. There's procedural history. There's citations to earlier authority, and lengthy discussions of legal doctrine, right? And the temptation is to start at the beginning and to try to understand every sentence immediately. And that approach usually leads to a lot of frustration, all right? So a strong legal reader is going to begin by, orienting themselves to the dispute. So before worrying about every single legal argument, they focus on understanding who the parties are and why they ended up in court. They want to know what happened, what the disagreement involves, and what each side is asking the court to do. All right. So once you understand the conflict itself, the rest of the opinion becomes much easier to follow. Another thing that you should also understand is that the appellate opinions usually arrive after something has already happened in a lower court. All right. That means that the reviewing court is not encountering the dispute for the first time. The opinion often explains what occurred previously and why the matter reached the appellate court. Now, understanding that procedural journey helps researchers to make sense of the opinion's purpose. All right, so the appellate court is typically reviewing a prior decision, and the reader needs to understand what is being reviewed before the court's reasoning can fully make sense. All right, and honestly, one of the most effective reading techniques is identifying the court's conclusion earlier on. Students, sometimes worry that this is going to spoil the opinion somehow, but judicial opinions, it's not a mystery novel. So knowing how the court ruled often makes the reading the reasoning easier to understand because you can see where the analysis is ultimately heading. Strong legal readers are going to approach the opinion strategically. They're going to focus on, again, first understanding that dispute, the procedural posture, and the court's ultimate resolution before diving into the legal reasoning itself. So once those foundational pieces are clear, the opinion does become far easier to analyze and to remember. Now, as you become more comfortable reading judicial opinions, they eventually, people will realize that courts often tell readers what matters most if they know where to look. All right. So one of the challenges of reading cases is that not every sentence carries equal importance. Some portions are going to provide background information. Some will give procedural history. Some are going to summarize arguments made by the parties. And hidden among all of that material are the passages that actually drive the court's decision. Okay. So experienced legal readers are going to learn to recognize those moments. Judges will frequently signal important analysis through their writing. Okay, so an opinion may suddenly state that a particular fact is critical, that a prior decision controls an outcome, or that an exception applies under specific circumstances. Those signals often indicate that the court is moving into the reasoning that ultimately supports its conclusion. And honestly, that's one reason that careful reading matters so much in legal research. Students will sometimes read opinions too quickly, and they'll focus primarily on reaching the end of the case, okay? But strong researchers are going to slow down when they encounter language that suggests that the court is emphasizing a particular point because those passages often reveal why the case was decided the way that it was, all right? Another important habit involves looking up unfamiliar terms immediately rather than just guessing their meaning. We're not looking for context here, okay, like we were taught to do in elementary school. Legal opinions frequently have technical terminology, specialized legal concepts, and occasionally you'll even have Latin expressions that you may not be familiar with at all as a new researcher. And so students will sometimes convince themselves that they generally understand that meaning through context, and they'll continue reading without verification. And the problem is that legal terms often carry very specific meanings that differ from ordinary usage. So even a small misunderstanding early in the opinion can create confusion throughout the rest of the analysis. Okay? And honestly, legal vocabulary works like specialized professional language. So like medical professionals, engineers, and accountants, they all have terminology that carries very precise meanings within their fields. The law operates the same way. So a strong legal reader is going to become comfortable with pausing to verify any unfamiliar language before moving forward. And that extra effort often saves a lot of confusion later on because it allows the reader to follow the court's reasoning accurately from the beginning. Okay. And over time, you'll discover that reading the cases, it's going to become so much easier. The terminology is going to become familiar, procedural concepts become recognizable, and then your judicial writing patterns are going to start repeating themselves. So what initially feels intimidating gradually will become much more manageable because researchers are going to learn how courts communicate and how judicial reasoning is typically organized. Now let's talk about the case brief. One of the most valuable skills that you're going to develop is the ability to prepare a useful case brief. And students often hear the word brief and immediately think about a, lengthy legal argument that is filed in court, right? Or a legal document rather. But a case brief is something that's very different. It's a research and study tool that is designed to help the reader understand, organize, and remember the most important aspects of a judicial opinion. So the purpose of a case brief is not to rewrite the entire opinion. If a brief becomes nearly as long as the case itself, then it's failed to accomplish its purpose. A strong case brief, though, captures the essential information in a concise and organized way. And the goal is to create a document that allows the researcher to quickly understand what the case involved, what legal issue was presented, how the court resolved that issue, and why the court reached its conclusion. Okay? Now, one of the most common mistakes that students make in learning how to write them is trying to include too much information. Beginning researchers often worry that leaving out details will cause them to miss something that's important. And as a result, they sometimes will produce briefs with very lengthy quotations, excessive citations, and a lot of unnecessary facts. The final product then becomes very difficult to review because it contains almost as much information as the original opinion. Okay? The strong case brief is going to focus on clarity rather than volume. All right. Another common mistake involves inserting personal opinions into the brief. You're going to have strong opinions about cases, and you're going to have times where you're going to strongly agree or disagree with the court's reasoning. But the purpose of the case brief is to accurately capture the court's analysis and not to evaluate whether or not the decision was fair or correct. All right. And I swear to you, there are going to be times when, you are going to be able to critique judicial reasoning, right? But effective case briefing requires separating out those personal reactions from an objective analysis of what the court actually said. All right, and that discipline, it's going to become extremely important throughout legal practice. Again, you have to first understand the authority accurately before you can do anything to evaluate it critically. All right, so a well-prepared case brief is going to serve both as a learning tool and a research tool, and it's going to help you to develop stronger analytical skills while creating a useful reference that you can revisit later when you're studying legal doctrine or you're conducting additional research. All right, and this is our last one. So once you begin preparing case briefs regularly, you'll discover that most of them are going to follow a fairly consistent structure. And the purpose of that structure is not to create busy work. It exists because legal researchers need a reliable way to organize information so that they can quickly understand a case long before, or I'm sorry, long after rather, they originally read it. Okay. So the first thing that you're going to identify is the case itself. So knowing the case name and its citation is going to allow the researcher to locate that opinion again later and place it within the broader body of legal authority. Over time, you will begin recognizing important cases almost immediately from their names because certain opinions become foundational within particular areas of law. Now, after identifying the case, you will focus on understanding how the dispute arrived before the court. That procedural history is often overlooked by beginning students because it may not seem like it's important, but it can be incredibly important. A case can reach an appellate court after a trial, after a summary judgment, after a dismissal, or some other procedural event, right? So understanding what happened below, helps to explain why the reviewing court is even addressing the issue and what authority it has to resolve the dispute. All right. Now, once the procedural posture is clear, researchers then turn their attention to the facts. And one of the biggest challenges here is determining what facts actually matter. Okay, so judicial opinions often contain a large amount of information, but not every detail has influenced the court's decision. Okay, so a strong legal researcher is going to learn to distinguish between a background information and legally significant fact. All right. It's going to become a lot easier with experience because, again, you're going to recognize the types of facts that courts repeatedly emphasize when they're analyzing particular, legal issues. Then you'll identify the legal question that is presented to the court. That is often referred to as the issue. Now, a lot of students will struggle with issue statements initially because they tend to write them either too broadly or too narrowly. The goal is to capture the specific legal question that the court needed to answer in order to resolve the dispute that is before the court. Okay? Now, after identifying the issue, the researcher is going to determine how the court answered it. And the answer is commonly referred to as the holding. Students sometimes confuse the holding with the court's reasoning, but they're not the same thing. The holding tells us the court's conclusion. The reasoning explains how the court arrived at that conclusion. Okay, and honestly, the reasoning is often the most important part of the entire opinion. Future courts frequently focus on a court's analysis because that reasoning helps to determine how the decision should be applied in later cases. So understanding the court's logic allows researchers to compare the cases, to distinguish unfavorable authority and to predict how similar disputes can be resolved in the future. And then finally, the researcher is going to note the court's ultimate disposition of the case. And that's going to tell us what happened procedurally after the court completed its analysis. Did the court affirm the lower court's decision? Did it reverse it? Did it send it back for additional proceedings? So understanding that final outcome is going to complete the picture and allow the researcher to see how the court's legal analysis affected the parties that are involved. All right. And this is why case briefing remains such a valuable exercise. Students sometimes view it as a study technique that's only used in school, but the skills developed throughout briefing actually translate directly into legal practice. Briefing teaches researchers how to identify those relevant facts, how to isolate out those legal issues, how to analyze judicial reasoning, and then how to organize, a lot of complex information both clearly and efficiently. And those are skills that legal professionals are going to use throughout their careers. And that's it. Let me know if you have any questions. Bye.